As an employment attorney who helps employers of all sizes, we often get questions about severance agreements and how we can help you. So I wanted to demystify some of the issues for you as to what goes into a severance agreement. A severance agreement is something that typically a lawyer is going to prepare for you. It's going to include a release of claims by the employee, and it may include provisions about how the employee is going to transition from your business. It's more art than science to figure out how much money that you want to give an employee. But the typical rule of thumb that most employers want to use is 1 week of pay for every year that they've worked for you. But it's going to vary depending on the circumstances, what the employee did to deserve to be fired in the first place, or how much money you have to be able to give them. For the most part, you can offer a severance to any employee that you want. You can get to pick and choose which one, if it's a long-term or short one, or one that you may just have a concern that they may end up trying to sue you. There are some rare cases where you may have to offer it to multiple people if you decide to offer it to one, but for the most part, you get to choose. Again, a severance agreement should be prepared by an attorney because there's a lot of complicated pieces. They include a release of claims that could be mutual or not. You're going to have information about how the employee is going to transition from you. You may want to talk about whether there's a confidentiality provision in there, and also whether you want to have a non-disparagement where you say that the former employee can't badmouth your company. There's also a potential that we can include what's called a clawback, meaning if they violate the other provisions of the severance agreement, that you may be able to go in and get your money back from the employee. Most of the time, you're going to offer a severance to somebody after you fire them, but there are times you might decide to offer them a severance before you fire them. For example, if you have an employee that you're concerned about the termination, if you think it could be risky, or you just want to help them transition out a little faster, you may offer them a choice of a performance improvement plan or being separated with a severance agreement. So a severance agreement can be used in both, but typically it's after termination. In Oregon, there's a few things we need to be a little concerned about. By statute, we need to be very limited as to what we include as part of a confidentiality and a non-disparagement clause. We also can't release workers' comp claims, and wage claims are very limited as to what we can do. Despite the limitations, severance agreements are very important for employers and something you should consider. At Saalfeld Griggs, we've been helping employers for a long time. If you have questions about severance agreements, please contact us. So, sorry. Good, I'm getting my first outtakes in already. I like that. Oh, hello there. I'd love to, love the opportunity to get your business. There, that was great.